Hello, welcome to AnusheelanIAS. This is Sankirtana. Let's discuss some important topics in Indian Polity Lecture Series. Today's topic is Judicial Review. We will also discuss judicial activism and judicial overreach in the same video by solving some PYQs. By watching this complete video, you can get a great idea of the topic. Now let's go to the first question. Judicial review in the Indian Constitution is based on rule of law, separation of power, procedure established by law, due process of law. Answer is option C, procedure established by law. What is judicial review? Now we'll discuss that. Judicial review means it is the power of the judiciary to examine the constitutionality of laws, executive orders and government actions. If any of these are found to be violating the constitution, then judiciary can declare them null and void. In simple terms, judicial review means checking if the rule is right or wrong and it is according to the constitution or not. Judges checks whether a law or a rule made by the government it is according to the constitution or not. If the law is against the constitution, the judges can say law is wrong and cancel that law. Let's discuss with an example so that you can understand better. Imagine a school says only tall children can play in the background. Short children are not allowed to play. In this rule, it is unfair that only tall children can play in the ground. If this rule is unfair, then it is against the school values. Then principal cancel it. Like that, in judicial review, the court cancel the unfair laws. We can also see judicial review in Minerva Mills case. 1980. Court struck down the parts of 42nd Amendment Act for violating the basic structure. Like that, court cancelled all the unfair laws. Judicial review is not mentioned anywhere in the Constitution. It is derived from the Articles 13, 32 and 226. You see this picture. In this, a judge wearing a black coat and holding a glass over a paper saying new law. It is a government rule. The constitution book is open here. That is saying that law is unfair. And he is checking whether the rule is according to the constitution or not. Here in the background, worried citizen is there hoping that judge will help him. That is judicial review example. Now let's discuss some more PYQs. The power of judicial review is exercised by the Supreme Court only in constitutional matters, only in civil matters, in constitutional and legal matters, none of the above. Answer is in constitutional and legal matters, the power of judicial review is exercised by the Supreme Court. Which article of the Constitution provides for judicial review? Option A, Article 14, B, Article 19, C, Article 32, D, Article 13. Answer is option D, Article 13. Article 13 says, all laws violating the fundamental rights shall be void and grants courts the power to strike them down. Next question, judicial review in India is a fundamental right, DPSP, basic feature of the constitution, none of the above. Answer is option C, basic feature of the constitution. In Keshavananda Bharati case, it is told that judicial review is a part of basic structure doctrine. Next question, which of the following statements is correct regarding judicial review? It is mentioned in the constitution. It is limited to criminal matters only. It enables the courts to strike down unconstitutional laws. It is only applicable to state legislations. Answer is option C. It enables the court to strike down the unconstitutional laws. It is not mentioned in the constitution. Next, which of the following is true about judicial activism? Option A, it promotes social justice. Option B, it helps to protect the environment. C, it stays away within the boundary of law. D, it sometimes fills the gap in absence of law. Here it is judicial activism. One more important topic. Answer is it always stays within the boundary of law. Now let's discuss judicial activism. What is judicial activism? It means proactive role played by the judiciary in protecting the rights of citizens and promoting justice, often by interpreting laws creatively or even filling the legislative gaps. In simple terms, when government does not do its job and people are suffering, judges or the court step in and give orders to help people. Let's discuss an example so that you can understand better. If a park is dirty and people are complaining every day, but government does not do anything, then court say that clean the park in 7 days. That means judges are helping people even though it's not their job. See in this picture, a judge is helping a poor and a sad citizen holding a sign card, please help us. In the background, parliament and the government office with the closed doors, judges holding a scroll card saying temporary guidelines to help the citizens. That is judicial activism. Next topic is judicial overreach. This is also important topic. What is judicial overreach? That means doing others' work. Judicial review means judiciary crosses the boundaries of its domain and interference in legislative or executive actions. When courts start making laws rather than interpreting them, that is judicial overreach. Imagine a principal not only checks rules but also starts teaching in the class, making school timetables and punishing without a reason. That's not the principal job but doing it. Like that, here judiciary also does the other work rather than doing its own work. In this picture, a judge is sitting in the chair writing new laws like parliament. Parliament make laws, but here judge is making laws, and he is also giving instructions to the officials here. The parliament and the government people in the background are upset, and there is a signboard, that's not your job. Here judge is doing others' job. This is the example of judicial overreach. Next question, which of the following cases is related to judicial activism in India? A. Golaknath versus State of Punjab. B. Keshavananda Bharati versus State of Kerala. C. Vishaka versus State of Rajasthan. D. S.R. Bommai versus Union of India. We have already discussed about all these cases in our previous videos. If you want, go and check them. Now here answer is option C, Vishaka versus State of Rajasthan. In this case, let's discuss brief about this case. In 1992, a social worker named Banwari Devi in Rajasthan was gang raped while she is trying to stop a child marriages. The attackers were protected by the system and no proper legal framework existed to deal with sexual harassment at that workplace. Then women groups in that place filed a PIL in Supreme Court under name Vishaka. Then what did the Supreme Court do? there was no law in India at that time to protect women from sexual harassment at the workplace. Then Supreme Court created guidelines using fundamental rights 14, 15, 19 and 21. Those are Vishaka guidelines. Key points of that Vishaka guidelines are: sexual harassment of women is defined in that, duties of employers are defined, education and awareness, that is employers should educate employees on workplace dignity and harassment laws. This is today's lecture. If you want some more interesting content like this, please subscribe to our YouTube channel. You can also join in our Telegram channel AnusheelanIAS by this QR code. You can also download our app AnusheelanIAS from your Play Store. Thank you.